Hi, everyone. We're about to start. I'll just give it one more minute. We have a packed agenda, so we'll start promptly.
Hi, Corey.
Hi, Eleni. How are you?
Good. It's good to see you.
I see some other familiar faces as well. It's good to see all of you.
All right. Can everyone hear me? Thumbs up. All right. Well, welcome, everyone. Thank you for joining us today. My name is Maya, Senior HR Consultant at H2R, and your host. We are super excited to announce that we will be hosting our Lunch and Learn webinar series every month with different speakers and topics. So if there's a topic you'd like to hear, please let us know. We have an incredible group of speakers today, a lot of great information to share. And I encourage everyone to submit your questions as we go along in the chat box, and I'll make sure to answer them as we go along. So to kick things off, we have Evan Campbell, a labor and employment lawyer, partner at Fillion Wakely, who will be speaking to us about some key legal updates. And of course, what's a legal update without a Bill 149? And some
Maya, you're muted.
oh, sorry about that. Can you hear me? All right, so I was introducing Evan Campbell, a labor and employment lawyer, partner at Fillion Wakely. He will be giving us key legal updates and what's a legal update without Bill 149 and some relevant case studies. And he will also cover the Working for Workers 5 Act, which was just introduced on May 6th. So take it away, Evan.
Thank you so much, and it's great to be here and have the opportunity to speak to you all. As mentioned, I welcome questions, so throughout the presentation, feel free to enter the questions in the chat and we can hopefully engage in a bit of discussion. So as mentioned, I'm a partner at a law firm called Fillion Wakely, and we are one of the largest firms in Canada that only represents employers with labor and employment issues. And we are about 55 lawyers with 4 offices in Ontario. And so we have a bit of a jam-packed review, so I'll jump right into it. And as mentioned, we're going to start by talking about Bill 149. We'll get through some various pieces of legislation, and then at the end, we'll do a bit of a high-level touch on a few cases that came out the last few months, just to flag some issues for consideration. So starting with Bill 149, and I'm sure you've all read some of the news articles and some of the info about this new piece of legislation. But the Ontario government has been busy for a few years, keeping myself and I know all the H2R team very busy updating policies and making tweaks on practices. So this is the most recent change. And so this piece of legislation makes, I would say, a handful of tweaks to the Employment Standards Act. And one of the changes that I think has gotten the most news is in relation to job postings. And I know Jen from H2R is going to talk a bit more in detail about this. So I'll just provide some high level comments and then she can fill in some of the additional details for us all. But the changes include what we have to post on the job postings. They include some changes in terms of what we can't post. So one of the things we can't talk about now is in relation to a requirement that an applicant have Canadian experience, which I think arguably would have been discriminatory even without this modification to the legislation. The other interesting piece, and maybe we'll jump to the next slide, is in relation to AI. And Yeah, we'll go to the next one, Alina. So in terms of this AI piece, which I think is interesting, as I mentioned, Jen will go over some of those other details as part of her discussion. But I found this particularly interesting in that we've all heard lots about AI over the last months, and I think is impacting all industries. And so there's been lots of discussion about AI use in the employment sphere, including in recruitment practices. And there's been some concerns raised by the Ontario Human Rights Commission about how that could lead to discriminatory outcomes in the hiring practices. And so again, I'm not an AI expert, as you can probably guess, whether it will have a discriminatory impact or not. I defer to the AI experts on that. But the key takeaway for all of us is that part of the new legislation is a disclosure aspect on job postings, meaning if you're using AI as part of your recruitment, as part of your hiring practices, then it needs to be stipulated in those job postings. There's no actual requirement in terms of how and when and what you can do with AI, just really an informational requirement that the applicants are advised if AI is being used as part of that process. So again, I'm sure this is the first of many interesting changes that will come through the use of AI in all aspects of the employment world. But so I think this is just a little snippet of what we may get as things unfold. So beyond the hiring, the job posting, I think has a lot of really important pieces to it. There's also some other changes, really a basket full of different tweaks. So I'll just touch on a few of them just to flag some issues for consideration. And this, whether it is applicable to you, will depend on your industry, depend on the operations, etc. But some of the high level changes is firstly, the definition of employee under the Employment Standards Act was modified slightly to include an employee who's engaging in activities as a part of a trial period. And really, the purpose of that was to close the loop in relation to anyone who's engaging in certain activities that people could arguably view as not work. But in this context, anything that someone does as part of this trial period, they are quote unquote an employee, which means they're entitled to protections under the act. Again, many of the organizations I work with, would be paying them minimum wage and all that stuff regardless, but just something to be mindful of in terms of this notion of a trial period. There's also restrictions on when we as employers can deduct wages or deduct from wages. And so many of you are likely aware that as a general rule, we can only take things off employees' wages where there's a court order, there's statutory reductions, or there's consent from the employee. There were a few minor other loopholes that existed that I would view them, and essentially the legislation closes those off. And those loopholes were where an employee was working at a restaurant, a gas station, and a customer left without paying. There's actually some exceptions with allowed certain deductions in those scenarios. So those loopholes have been closed. The other piece I would flag is around tips and gratuities. So again, if you're assisting or working in a business which has tips and gratuities, there's some new tweaks to the legislation in terms of how it can be paid, as we flagged in the slide. But also the other important piece that I would reference is that if you engage in tip sharing, the tip sharing policy now must be posted and provided in the actual workplace. Again, just a practical requirement in terms of the specific policy. And the last piece on this new legislation is around vacation pay. And again, many of you know vacation pay as a general rule is paid to employees before they take their vacation. But there are scenarios where employers want to pay vacation pay at different periods. One very common one is on a pay period. So as opposed to having it accrue and then use when the person goes on vacation, some positions, some industries prefer that the individual is paid that accrued amount on each pay period. And so if, for example, those type of scenarios it's very clear that there must be a written agreement to permit that type of alternative pay of vacation pay. And again, other scenarios could be if you, as the employer, want to accrue all the vacation pay and pay it out at a certain time at year end, that could also be captured by this and require a written agreement. And again, I would say in my experience, many employers who are engaging in those practices already have that type of structure in place. But again, something to flag for you all. If you're engaging in alternative ways to pay vacation pay, we just got to make sure that we have that properly documented with the employee. Now, that's the first piece of legislation. As I mentioned, the government's constantly busy, keeping us all busy as employers. On May 6th, they announced Take 5, the Working for Workers 5 Act, which again is a basket of all sorts of different tweaks to various legislation. And this is just announced a few weeks ago. We're still getting details from the government in terms of what it will actually look like once it's finalized. But I did want to flag a few issues for you all as we work through this legislation. So in terms of some of those changes, let's go to the next slide. There's a host of tweaks in terms of apprenticeships and trying to promote those. There's requirements in terms of joint safety committees being virtual, which I think makes a lot of common sense in many workplaces. One of the changes, which I think we've all heard, which I'll just flag, is the sick note piece. And so the government, as part of this new piece of legislation, included a prohibition on employers requiring sick notes for the individual taking sick leave under the Employment Standards Act. And so just to touch a bit on that, this is limited to the sick leave time under the ESA, which is 3 days. And it doesn't take away our ability to ask for medical documentation as part of a return to work, of course, beyond the 3 days, and in terms of our general obligation to accommodate under the Human Rights Code. So I think there's limitations for sure when people are taking sick leave under the ESA, but I wouldn't interpret this to mean that you can never ask for a medical note. In actuality, my position as employer counsel would be that there's many scenarios that not only can we, but we should be asking for medical documentation as part of our obligations to ensure a safe and appropriate return to work. So let's talk a bit about some more change on the next slide. So of course, there's good measures being taken to promote women in skilled trades, as we've outlined on the slide. One of the other interesting changes or potential changes is this notion of virtual sexual harassment in the definition of harassment under the Occupational Health and Safety Act. And so we all know that the Act has specific definitions of harassment and sexual harassment in the Act. And there's various obligations on all of you as employers to ensure you provide a safe workplace and to investigate allegations of harassment. But there's this potential to expand that definition to capture this notion of virtual sexual harassment. So again, an interesting response to the reality of today's workplace. I think arguably, even if harassment or sexual harassment is occurring virtually now, based on the current definitions, you still obviously need to respond and deal with it in the appropriate manner. But I think it's a signal from the government of the change based on, again, the reality of the current workplace. There's also some further tweaks on the job postings piece, which is going to be interesting to see what is finalized once this legislation is enacted. There is a requirement under this new legislation that those who are interviewed are advised as to the outcome, essentially meaning if they don't get the job, that the position was filled. So some positive obligations on the employer to go back to all of the individuals that they've interviewed, which I think, again, hopefully many of you already do that just in terms of good reputation, but this will put that into law. So other changes that this may result in is additional fines under the Employment Standards Act. And we have seen an increase in fines in all employment legislation over the last number of years. There was significant changes and increases for potential fines under the Occupational Health and Safety Act. For the past few years, there's increases to fines under the Employment Standards Act. And this is, I would say, another kind of increase. And this is in relation to individuals. So again, if you're a business owner, a director, and you engaging in conduct which could contravene the Employment Standards Act, there is the potential for fines. And historically, or under the current legislation, the max fine is $50,000. This new modification would increase that fine to $100,000. So again, I know all of you, the reason you're watching this is because you're going to be in compliance and you're working with H2R, so no doubt you'll be in compliance, but there is massive sticks if things are not properly followed. So that's a very quick overview of some of the key pieces of the new legislation. And I thought it'd also be helpful just to touch briefly on some recent cases, which I do think have a direct impact on you as employers. And so just with the last few minutes I have, let's touch briefly on these cases. And so starting with a bit of a case study, and this is from a real case, which we'll talk about, but the basic facts are that the female worker, this is a restaurant, manager's male, obviously older, the manager is engaging in repeated comments of a sexual nature, engaging in inappropriate conduct and comments. The applicant and another coworker have experienced this behavior, and the response from the employer is to offer to transfer the applicant to another location. That's the response. And I think I won't even put it out to the audience. I think we all know that's not a good response, and that ultimately leads to the outcome. We'll see on the next slide. And so this is a decision from this year, just a few weeks ago or months ago, this 2024 decision, where of course the tribunal found that the conduct by the male supervisor was of course unacceptable, leads to a poisoned work environment. But the real kicker for the employer is that when they were advised of the issue, they didn't take any action, right? They knew about the inappropriate conduct, failed to investigate, failed to address it. And as a result, we have the outcome here, $35,000 award to the individual. Along with, I think there was some other non-monetary remedies, such as training for the employer, etc. So the lesson from this case, this very recent case, which hopefully all of you are well aware, is that when an individual raises concerns, that obviously triggers a positive obligation on the employer to investigate and to appropriately address the conduct. And of course, asking the applicant, the complainant, to transfer is most definitely not an appropriate response. Another couple of cases, which we'll touch on briefly, employment contracts, the bane of existence for most employer councils and HR folks in today's world. We all likely know that the courts despise employment contracts and despise termination clauses or any attempt on the part of the employer to limit or minimize an employee's entitlements on termination. And this is just the most recent case, again, from 2024, where the employer terminated a fixed term employee. And it was 2 months into a 2-year contract and gave her 2 weeks notice. And again, at issue in this case was, does the clause in the employment contract, is it enforceable? Does it eliminate the employee's entitlements to additional payment, additional common law notice? And unfortunately for this employer, the court found that the termination clause was invalid. And a couple, I think, important pieces from this case. One, again, this individual is on a fixed term contract, which is a potential area of liability in that if you terminate someone on a fixed term contract, and if the termination language in that contract is void, the individual is entitled to payment for the remainder of the term, regardless of whether they get another job. So there's significant potential risk on the employer. And that's why I would suggest caution in using fixed term contract. I think sometimes employers think they're fantastic. Put this person on a 2-year contract, it'll be great. 2 years comes to an end and we all move on with our lives without having to pay anything, which in the perfect world, That's how it works. But we all know the world is not perfect. You get a bad employee, you fire them at month 6, and then potentially you have a 1.5 year liability that you're going to be paying if the matter turns litigious and your contract's unenforceable, which would be significantly less than simply firing a 6-month employee. So again, not to say fixed term contracts are bad, just that drafting is important, and when you use them, in my view, is important. So the other important takeaway on this, and let's go to the next slide, is, oh, this is a different case, but the other important takeaway on this is the very clear drafting on termination clauses. And as I often tell my clients, and I know I've had many discussions with H2R on this, and that drafting is critical. I want to make sure our termination clauses are drafted in the best way possible. But even in the best drafting, we have 50 lawyers. All we do is employer side employment law. All we do is draft contracts. We all work together to draft the best contracts. Even in that type of scenario, in today's world, there's always risk that we will be found, or the court will find a creative reason not to enforce a contract. So I think that's just the reality of the risk that we live in. Not to say we shouldn't have contracts. Contracts are still fantastic. We all should have them, and they all should be updated. Just that we've got to be cognizant of there's real risk. The last case I wanted to touch on was this Viewpoint Systems case, which was a decision issued last month from the Ontario Court of Appeal. It was a decision that myself and a colleague argued before the Court of Appeal, of course, represented the employer, and it dealt with whether the individual was entitled to any payment following a dismissal. And in this case, the employer had terminated the individual because they failed to comply with the vaccination policy, which had been implemented by the customer. And so ultimately, the Court of Appeal accepted our position and found that the contract was frustrated, which is a concept of law, and which essentially means the employee got nothing. Let's go to that next slide. And why this I would suggest is potentially a good decision for us as employers is that it affirms that when something arises out of the control of either the employer or the employee, then this can frustrate the employment contract. In this scenario, we argued that this vaccine requirement by a customer was no different than a new legislative requirement on the employer, for example, or a scenario which essentially prevents the individual from performing the job, such as, a new security requirement by a customer. No different than those type of scenarios where ultimately the individual can't perform their duties really at no fault of either side. But in that scenario, luckily, the court said, yeah, the employee shouldn't get a windfall of wrongful dismissal damages because the employer did nothing wrong. And so I think it's a good broad decision for us as employers. So rapid fire, I touched on a whole bunch of different stuff. Happy to take questions at the end. Of course, if you have any questions, of course, happy to take them offline as well.
Hey, I just sent it over to you.
Oh, you did? Okay, I just
Yeah.
heard my phone dinging a bunch of times. That was funny timing.
Yeah, that was me.
Okay, do you want me to look at it right now?
Yeah.
Sorry, if you can mute yourself. All right, if there's no questions, well, thanks, Evan, so much for that update. Definitely a lot of key takeaways to remember. We've created a guide, which you can reference here. Sarah just dropped it in the chat box, just with some key dates and a key resource for you to look back to for some of those key legislations that are coming up. So next up, we have our lovely Jennifer Ferron. She's our compensation catalyst at H2R and a certified compensation professional. Today, she's going to be speaking to us about getting our business ready for the pay transparency legislation. So take it away, Jen.
Okay, my timer's on, so let's go. You can go to the next slide, Eleni. So, welcome everybody. And I know I've been getting a lot of questions about this pay transparency stuff ever since our illustrious government made announcements about it. So some important things to know are what are actually going to be the requirements. Well, the quick answer is we don't know specifically yet. To Evan's point, there's parts of Bill 149 that took effect right away, and there's other parts that have not. And this is one of those parts that has not quite taken effect yet. So we're still waiting on the government to give us more precise regulations on what employers will need to implement in their job postings, for example. But the essence of it is that as employers, you'll be required to include what is called the expected compensation or compensation range in your publicly advertised job postings. You'll notice there's some terms there that we've bolded, and that is by design. Those are exactly the terms the government has not quite defined yet. So we don't know yet what expected compensation will mean. Will it mean, for example, the hiring portion of your ranges if you have formal salary ranges? Will it mean the full range? We don't know. Will it mean that you need to also post dollar values or opportunities around incentive pay, bonuses, commissions, that sort of thing? We don't know. And we also don't know whether you'll need to include information precisely, let's say, dollar values of things like perks and benefits. And finally, we don't know yet how the government will define or potentially limit or have exemptions for what they would call a publicly advertised job posting. We can make some pretty safe assumptions in that you should get prepared that your job postings, if you're posting to the outside world beyond your organization, you will need to post more information around compensation than you did before. But stay tuned, we will keep monitoring for when the government finally tells us what they actually mean that as employers we will need to publish. There are some other requirements. One of them is around retention of documents. And so you're going to be required to retain both your copies of your postings, your public postings, as well as the application forms associated with those job opportunities. And you have to retain them for a minimum of 3 years after the posting is no longer accessible to the public. So in other words, once you take it down. So if you forget to take down your posting, folks, even though it's quote unquote expired, it's 3 years from the time you take it down that you've got to retain those documents. So get ready for that if it's not as a general practice you already observe. And like I mentioned, we don't know when this is actually going live because our government punted that particular ball to the lieutenant governor to proclaim at some point in time. We can assume, and maybe Evan will have a comment on this, being in the lawyer world, if you look at what has happened in BC, they passed their legislation last spring, and by last fall, employers had to start posting those pay ranges. So it was a pretty quick turnaround from the time they passed the bill to the time they expected employers to start complying with it. If I had to guess, I would say we're probably going to see something similar in Ontario, particularly as we come upon election season, and there'll be some pressure on our politicians to make things happen. And this might be one of those things that they choose to make happen quickly. So what can we do to actually prepare for it as employers? The first thing you can do is a bit of housekeeping or reviews of your policies, processes, systems around recruitment and compensation in general. So review your policies and procedures. Start flagging areas that you might need to update once we get more precise regulations from the government on this part of the bill. So if you don't have a section in your job postings for compensation information, it could be as simple as adding the section and waiting to see what kind of details you're going to have to post in it. If you use applicant tracking systems, which many employers these days do, also known as an ATS, you might want to check with your provider, your systems provider, to make sure that they already, and if they don't already have these retention processes in place, that they implement them, because you will have to start keeping your postings and your applications for, as I mentioned, that 3-year period. If you're planning to change ATS providers in the future, you're going to want to make sure that the one you have right now, again, will allow you to download, archive, whatever you got to do to retain those records as you switch from one provider to the next. So those are some simple logistical things you might want to iron out while you've got the time, because we all have so much free time. But on the more specific pay side, because it is pay transparency legislation after all, what can we do to get ready? Well, the overriding message is get your house in order when it comes to compensation. So if it's been a while since you've looked at your compensation programs, framework, practices, policies, rates of pay, this is the time to look at them and make sure you're comfortable with them, because in a matter of months, you could be asked to start posting that information publicly. So that could be things like internal equity or compliance. So making sure that your job evaluations are up to date behind the scenes, that all your jobs are properly assigned to the pay grades they should be assigned to. If you have a job evaluation process or tool in place, if you don't have one, this would be an excellent time to consider implementing one, because it will only serve you well in enhancing your, let's say, compensation infrastructure and your discipline around pay before you have to start posting pay ranges, for example, in postings. If you have more than 10 or more people in Ontario under your employment, this is actually also not a nice to have, it's a requirement under the Pay Equity Act of Ontario. So from a compliance perspective, get that job evaluation going if you don't have it done, and update it if you haven't dusted it off in a while. Next slide, please. Obviously, we're going to be posting pay stuff publicly. So we want to make sure as employers that we're not ashamed of what we're posting from a competitive standpoint, right? So again, if you haven't looked at your market rates for local competitive or local talent competitors, it might be a good time to look at some market benchmarking, whether it's a full-scale exercise across your pay grid, whether it's just certain key mission critical roles that you want to make sure that your competitive, your rates are tight, competitively speaking. This might be a good time in the coming months to explore some market data and see where you actually are positioned as an employer before you're pressured to publish that information. Consider also, we talk a lot about cash when we talk about compensation, but think about your benefits and perks as well, your total rewards offering. Are you really competitive in the marketplace overall when it comes to the employee value proposition that you're offering? And of course, you want to make sure that anything you offer, whether it's cash or non-cash, the way that it is offered and administered and eligibilities are determined should be equitable internally for all jobs in your organization, ideally. Look at your pay grid for simple things too, like employment standards, minimum wage. I think Evan had mentioned in his slide deck that we are increasing minimum wage in Ontario to $17.20 an hour this October. So this is a good time to take a look at your pay grid, especially if you do have minimum wage jobs in your organization. Take a look at your pay grid and make sure that increasing your wages come this fall won't necessarily create pay compression issues with some of your other jobs that might be only slightly above those jobs right now. And if you do have compression, there's some strategies you can use to try and tweak your structure to address that. Remember that public postings also means internal, right? So while the government at this time is not asking employers to post, interestingly, they're not asking you to post compensation information transparently for your existing employees. They're only asking you to do it for the outside world. But you can assume one basically leads to the other. If you're posting your information publicly, employees will have access to it. So again, clean house, make sure you're comfortable that you don't have any skeletons in your closet internally around internal equity, pay equity compliance, market competitiveness, all of those things that an employee might be miffed about. If all this time they've been thinking that they're well paid, whether that's relative to the outside world or whether that's relative to their colleagues inside the organization, when you start posting pay ranges, particularly if you're an organization that has not had a great deal of pay transparency with employees up to now, it's going to be a pretty big culture shift just making that information available. And when it does become available, people will suddenly start scrutinizing where their pay falls within the ranges that you're posting.
Thank God we already.
So get ready is, I guess, the overriding message we can give you. Prepare a communication plan. Often employers will see this legislation come down the pike and they get into the weeds of the details of analyzing their compensation, but they forget to have a plan for how they're going to communicate and educate their people about all of this. Again, if you're not used to having to educate employees about how pay works in your organization, this is the ideal time to start getting ready to do just that, because any education you can do is likely to quiet noise and strife around pay if you prepare for it proactively. Other than that, our message is we can help. So everything we've recommended today is something we can help with. So if you need help, there's my time. I'm so proud of myself. Reach out if you need help with any of this.
Excellent. Thank you, Jen. That was really informative. So if anybody has any questions, again, you can drop them in the chat box or reach directly to Jen or us, and we'll get those answered. All right, so moving along, some H2R updates. So the training requirements in Ontario, I just wanted to briefly touch on this. We have designed an online compliance bundle within our H2R Learning Academy. It's our easy to use LMS, learning management system, and it ensures that you have the training required to comply with regulations under one umbrella, and it's all done online. In Ontario, almost all workplaces are legally required to provide 4 types of training to all employees, and that includes AODA, so AODA Part 1 and Part 2, soon Part 3, WHMIS, Worker Supervisor Health and Safety Awareness, and Workplace Violence and Harassment Training. Now, your workplace may have additional training requirements based on the number of employees you have or the nature of your work. So just reach out to us if you're not sure which training requirements apply to your organization, and we will work with you to establish those requirements. And whether you're looking for that training support I just mentioned or to outsource your HR department, looking for occasional HR program rollout, even covering some of the absences like a maternity leave, or just looking for some expert advice on your HR strategy, we're here to partner with you and make your life easier, as Jen said. And as you can see on the next slide, we provide a full range of HR services, but our most popular services include performance management, my favorite, HR policy development, recruitment, and compliance. And our newest service offering is immigration services. We have flexible plans, and we really work with our clients to ensure we can meet their budgets. So do reach out to either Jill or Deborah if you require more information on our pricing models. And if you don't know, well, if you do know that you need help, but you don't know where to start, you can talk to us about doing a health check of your HR practices. We partner with employment lawyers like Evan, and we really guarantee that all of our policies, procedures, and practices comply with employment legislation. I do see some questions trickling in. Gail. Gail's asking, would you have package rates to make sure all existing employees are caught up? Just reach out to training. Alini, what's the training?
Actually, Maya, I put my email in there. It's Deborah at your H2R, and I can address that with Gail or anyone.
Okay.
Thank
Perfect.
you.
Any other training questions or questions on our HR consulting services? Okay, and now to conclude our webinar for today, we have Jackie, the executive coach and workplace culture expert. I've known Jackie for many years, but she has 20 plus years of experience coaching and training leaders, and is really passionate about creating healthy, thriving, high-performing workplace cultures. And today she will be speaking to us about accountability versus blame culture. So take it away, Jackie.
Thank you, Maya. Hello, everybody. Good to see you. Hope you're getting some nourishment in on your lunch hour today. I know I snuck in 10 minutes while Evan was talking. Hope you don't mind, Evan. All right, let's dig in, Alini. So just a quick reflection for everybody. Think about a time when you made a mistake at work. And come on now, I'm pretty sure we've all made them. How did you and those around you respond to that mistake? And really, what was the impact that response had on the outcome or on the team dynamics? I don't know about you, but for me, particularly with the pandemic, we started to figure out the importance of accountability because no one knew how to do it virtually. Everyone was like, oh, and we thought it was clocking in and clocking out, right? And it becomes, no, it's like measured to their outcomes. And so I've noticed the word accountability is coming up a lot. It's being misused though, and it's driving me crazy. So that's why I wanted to do this quick little framing of the difference of an accountability culture versus a blame culture. So just think back on a mistake that you've made, or even think about it in the context of your work this week. Was there anyone on your team or an internal client that made a mistake, and how did you handle it? So I'm going to give you there's one little chart I want to share that I want you all to take with you. So whether you do a screenshot or you use our PowerPoint that we sent to you, that's the piece I'm hoping you'll take with you. All right, so let's move on. So why does accountability matter? So this is just my way of kind of grounding us and sharing my perspective of why accountability actually matters. And, you know, in the context of, if we want to create a culture of accountability, we have to remember, my fundamental belief system is that it's everything, a mistake is a learning opportunity. And so it's funny, just this morning I had this client, Liz, she's a high performer in a global company. And she was down and I said, Liz, your voice is different this morning. What's going on? She said, Jackie, I'm so tired of the organization not holding me accountable. I'm like, wait, what? I rarely hear people say, she said, I just want to be pushed. I want to be challenged. Because she's a high performer. So I wanted to share that because I don't know about you, but I felt that way in my life sometimes. It's like, if I matter enough and if I'm considered a high performer, push me, challenge me, hold me accountable. So keep that in that mindset in as we dance through this. So when we hold each other accountable, it's not rocket science, is it? We get improved performance, right? Where there's that sense of, hold it, like they're going to hold me accountable and I'm accountable to my team and I care about my team and or the customers. When we hold each other accountable, there's increased trust. We've all worked in teams and inside organizations. When we don't have the courage and or the vulnerability to hold each other accountable, we can lose trust. It's like, yeah, whatever, they're not going to hold me. And eventually even our high performers disengage and we start to lose trust in each other, let alone in leadership. When we're holding each other accountable, and notice I'm saying each other, I'm not saying this is just about leaders holding us accountable. Let's hold each other accountable as peers and normalize that. It's like, so that when we hold each other accountable, we get creative to say, hey, Jackie, there's something in your job that I thought you were responsible for that you don't seem to be doing. Can we talk about that? Am I misunderstanding your role? So let's problem solve how we solve it, right? So we get creative. And also when we're held accountable and our feet are to the fire, we want to deliver innovation and creativity. So we get better at problem solving. And the link to innovation and creativity is that when we are not held accountable, we might just do mediocre work and it doesn't push us to think outside of the box, to get a little bit more creative. Employee engagement will go up because the more and more that we hold each other accountable, the more trust that builds, the more creativity, the more fun we have with each other. So it spirals in the best of ways. Again, not if we're building a culture of blame. So we'll talk about that, the differentiator, in a moment. Also, when we're holding each other accountable, we're building adaptability and resilience. And there's a lot of things that I'm implying in my very short little 10 minutes with you, is that we're doing it well. Because, people are trying to hold each other accountable, they're not doing it well. When we're doing it well, we're fostering that trust with each other. When we're doing it well, we're creating a learning culture so that we can adapt and adjust and grow and learn. And also, lastly for me, why does accountability matter? It's ethical. It's the right thing to do, right? It's not shoving things under the carpet and dismissing it or not talking about it or being avoidant. We're holding each other accountable with a sense of value and integrity. And that's ethically the right thing to do. Anything else that you would add to this list? Why fostering accountability matters? Anything else that I should add to the list? Just put it in the chat for a second if something's popping into your head. All right, Nalini, and pop over to the next slide. So this is the one I really want you to pay attention to. Differentiating, and don't shift the slide just yet, Alini, just bear with me for a second. So I want to give you an example. I was thinking about it as Jen was talking. When people say the politician must be held accountable for his actions, politician, leader, I don't care who we're talking about. What we're really saying is that politician is to blame and must be punished for his actions. Accountability is not the same as blame or punishment. So to be accountable means to take responsibility for results, good or bad. It means finding solutions to problems and applying the lessons learned in order to improve future results. The future word's important. Being accountable is constructive because it's focusing on the future. To be blamed, on the other hand, is to be accountable and culpable for action, right? So blame is often assigned before all the facts are known and assumes that people, not the systems that they operate in, are the problem, right? So blame is not focused on the past. Sorry, is focused on the past. Blame is focused on the past and on punishing the offender, right? The thinking behind assigning blame is that identifying the offender and punishing them will correct the poor behavior. Not so. So I want to say that again. The thinking behind assigning blame is that identifying the offender and punishing them will correct the poor behavior. Not so. The reality is that the only thing that people learn from being blamed is to become better at hiding their mistakes, right? I wanted to kind of let that sink in. I'm thinking about it as a parent too, not as just as a leader. Think about that for those of you with children. All right, next slide. So this is the slide. This is the one, either take a screenshot or take it from the slide, the PowerPoint when we send it to you. When we have a culture of blame, the belief system in the org and in the team is that people are the problem, right? That people, the problems are friggin' headaches, and admitting career weaknesses is a career limiting thing. In fact, my client this morning, the global head of sales, she said, Jackie, if I admit this, I won't get any more promotions. I'm like, whoa, hold on, walk me through that narrative and where it comes from, right? The culture of accountability belief system is that people are problem solvers. It's like, okay, we missed this deadline, we missed this product, we didn't hit this target, whatever it is, we can solve this. Let's get all the people in the right people in the room to have this problem solving, right? We believe that problems are learning opportunities and that we are always still learning. So note the learning thing is pretty critical. I always say, if you want to build that culture, we got to intentionally build a learning culture, right? When we have that culture of blame, we're focusing on what is wrong. We're focusing on the individual, always fact finding, and we're focusing on the past. So when we truly have that culture of accountability, we're looking at what is wrong, not who is wrong. And the what can include a system of people, a team, and even an individual, but they're part of a bigger thing. So it's asked, if you're hearing who's wrong, say what is wrong, just to slightly shift the mindset, right? We're looking at the system, we're looking at the process, we're looking for the facts, not just narrative and storytelling, right? We're looking to the future, big differentiator from my perspective. And this is not about assigning punishment. It's like, how do we do this differently and never do that again? What needs to be different in order to make those changes and the results that we were expecting? See what happens, we stop making assumptions. We start considering alternatives. We stop creating a culture of hoarding knowledge and hoarding, our contacts and access to other people. We stop hoarding decision-making authority. I just did a culture mapping session with a company yesterday, and I asked them, how do we make decisions here? And the whole room went silent. And I went, okay, so walk me through. And they all said, we don't. She does, and pointed to the boss. I'm like, interesting. So we want to make sure that we're creating an environment that allows us to delegate decision-making authority, that we are getting practiced at surfacing the problems without blame and finding solutions together, that we're focused on not who do we distrust, but how do we build trust. I always say one conversation at a time, you either lose trust or you gain it. So it's incumbent upon all of us. If I'm on a project with Jen or I'm on a project with Jill, I'm going to say, what do you need more of from me to build trust? Where do you need me to step up? What do you need less of from me? So that every conversation we're leaning in with each other. So we're intentionally building trust with each person, each team, each system. Right? When we have that culture of blame, it's clearly about turf wars. When we have that sort of really holding each other accountable, we build more creativity and collaboration, co-creation, nothing better. Right? Stop resulting in holding and let's move towards taking an initiative. When you've got an organization where people have the courage to take risks and they're not afraid to fail, that's a really good sign. It's like I've got one org, I just love them so much, and they've done it intentionally. But I've got this new chief product officer, Jason, and JT said to me the other day, he's like, "Hi." He came from Intuit, so he's been led by a really great leader with a really cool company. And JT said, "Oh my God, Jackie, like these people are okay if I fail." I'm like, "Say more, JT." He goes, "No, they told me I'm allowed to fail at everything once, but I'm not allowed to fail twice." I'm like, "Okay, that's good." But he now that he's been there a couple of months, he believes them because they've been modeling that's actually true. It's not just language, right? And when there's a lack of innovation and creativity and initiative taking, we know that we've probably got a culture of blame versus a culture of accountability. So I just wanted to really share this chart with you because I have found it exceptionally useful. I had one organization use this as an audit. They called it the blame audit. So the whole org, we created a little chart with this chart, and for the whole week, for 5 work days, every meeting they went to, they go, they'd score each of these categories. So it was just a playful way of trying to bring this language and this mindset into their organization. All right, let's move on to the very last, my closing thought for you. All right, thanks, Alini. Next one really comes from Vince Lombardi. Individual commitment to a group effort. That is what makes a team work, a company work, a society work, and a civilization. So as a leader, it is our job, right, to intentionally build that culture of accountability versus blame. So I hope the differentiation in the language helps a little bit so that you can get more intentional at creating that culture of accountability and moving more and more away from the blame, because it doesn't work. It shuts people down and disengages them. You know where I am if you want to have a conversation about how to do that, the many steps that it takes to build that kind of culture over time. Thank you for listening.
Thank you, Jackie. That was very insightful. Now, do you offer like a deeper dive, or is that one-on-one coaching or just a conversation?
It depends, Maya, for sure. Like some companies where we like think about this one global org, we specifically intentionally built that culture of accountability over 1.5 years with measurements throughout. So it was a full-on consulting gig for the whole leadership team and their people. And then in other cases, it's like I've got a client this afternoon. We're going to talk about what do we do to bring in psychological safety and create a learning culture. So it'll probably be a couple of training sessions with maybe some coaching. So it's just designed for the org and their budget and what's appropriate for them.
Okay, excellent. Are there any questions now? I'm going to be opening it up. Just wanted to thank all of our speakers. I don't see any messages in the chat. So we could conclude it right now, have 6 minutes back into our schedules. Again, thanks everyone, and we will be hosting another Lunch and Learn webinar next month, so stay tuned for a date to be released really soon. And if there's any questions, if there's no questions, thank you, and we'll see you again. Oh, hang on, will Jackie's slides be shared? Jackie, are you okay with sharing the slides? Yes. We can email the slides to the group. How can we get a recording of this webinar? We will be, the recording usually stays on the Teams. So if you don't see it, reach out and we will send that to you. Okay. Great. Thank you, everyone. Enjoy the rest of your day.
Thank you.
Thank you. Bye.
Bye.